All right, everyone, welcome in 8:06 on this evening, this Thursday evening. Thanks for joining us for this latest segment of Wave Extra. I'm your anchor, Jose Sosaya, breaking down more in-depth coverage, extra analysis for you because there's so much to cover when it comes to this, just the first trial of several we're going to be following through this early part of the summer with Stephen Lawson. We have seen it move pretty fast this first week over the first 3 days. That doesn't mean there's not a lot of testimony, insight, things we can glean from the witnesses we've heard, the approach both sides have taken as far as the narratives they're wanting to tell the jury. We've heard the prosecution pretty much through most of the week, and today they just finished wrapping up. So it'll be up to the defense to make their cases. So again, thanks for joining us as we're covering this pretty high-profile, interesting trial with a lot of different connections, relationships, twists, and turns. So on this day 3, again, this all hinges on Stephen Lawson's presumed, or the allegation of a presumed role in the disappearance of Crystal Rogers, a Bardstown mom, almost a decade ago. So to recap, the prosecution called their last witness today, and what we're going to center on this discussion as you join us on Wave Now, on our multiple social media platforms, is 2 phone calls that the prosecutors say Stephen Lawson made from jail in 2024, January of 2024. One of them was to his own mother. The second phone call was to an unknown person, at least when it comes to police and prosecutors. But we are going to cover the text of that conversation in this segment and throughout the night, so you see really kind of what the prosecution is making the case is pretty implicating information when it comes to what Stephen Lawson knew back then. In fact, the audio playback of that phone call, the jailhouse conversation that Stephen Lawson had with his mom, it was so staggering for Crystal's mother, Sherry Ballard. Our team noticed that she had to step out of the courtroom for a moment, just bringing back a well of emotions and heartbreak, not just for her, presumably, but for all of Crystal Rogers' family. And in that vein, you can sort of see what the approach the prosecution is trying to make. Now, all throughout the trial, the defense, as Stephen Lawson would want, has been trying to poke holes in prosecution's cases, the Commonwealth attorneys, trying to create as much reasonable doubt. Earlier today in my discussion, you'll hear a part of this with our Wave legal analyst, Leland Hulbert. In a criminal case like this, when you're talking about beyond a reasonable doubt, he equates it as, wanting the jury to believe that a defendant in a case is 90 to 95%, or the merit that the prosecution hit, you've cleared with the evidence in case you've presented that it is 90 to 95% true that this person did what they are accused of committing. That was the math he offered to me as far as where the jury could stand. And the defense, through it all, tried to suggest the prosecution witnesses, a lot of them we heard from in day 2 in particular, that they weren't reliable for a litany of reasons. It's been so long since these events happened back in July of 2015. Again, the age of the case and different memories, how they might remember all of the finer details. Even calling into question some of the witnesses who, again, have relationships with so many other people involved, not just Stephen Lawson, but his son, Ann Brooks Hauk, who we will discover a lot of information about them coming up soon over the course of the summer. But needless to say, the defense, that is the case they're trying to lay out, and now they're going to be using their witnesses. We heard from the first to try and discredit some parts of the investigation. How much of it they will try to discredit, we don't know that at this point. That's merely speculation. But without any further ado, I want to let you tune into parts of my conversation. As you tune in, kudos to our team with all of the coverage, because a reminder, we don't have cameras in the courtroom, so we're not able to get the audio reaction, the video reaction, see people's faces as they're processing this all in the courtroom. So we've been relying on our producing team and our reporters in that courtroom in Bowling Green to give us the information that we need to then share with you. So I'm going to play you part of my conversation with Alina Noakes earlier today. Okay, everyone, thanks for joining us for this part of our Wave Extra coverage, day 3 of the Stephen Lawson trial. I want to bring in our Alina Noakes, our reporter extraordinaire. She's been covering this trial from the very beginning down in Bowling Green, providing us all those handwritten notes because, again, remember, we can't have cameras inside the courtroom per the judge's order. So Alina, our team, sending us back those big updates as they're coming in. I will set up Alina because we have a camera there for her. So Alina, thank you for making time to talk to us. I want to open the floor to you, as long or short as you'd like to explain kind of what your big takeaways are from today, what you heard in the courtroom that folks at home should really pay attention to.
Well, Jose, that's a lot to cover today because we honestly had some pretty big moments in the courtroom. I want to first start, though, with the phone calls that we heard. Those are some jail calls that Steve Lawson made from jail just a few months after his arrest in this case, in which he called two people, his mom and an unknown caller, someone who was not identified to the jury or to us in the audience as having called him. And during that time, they really pressed him for information about this case. He admits that, yes, he was involved in the Crystal Rogers car situation where it was found on the Bluegrass Parkway, and he picks up Joseph Lawson, his son, from that car. Again, he's previously already admitted to the jury that he has tampered with evidence in this case. So he makes those admissions. But notably, both his mom and this unknown caller press him, believing that he has information about where her body's at. He emphatically says that he has nothing to do with the body, that he has no idea where she's at. But again, they question, why in the world have you not said anything? One caller saying, it's been 8 years and why, you could have saved this girl's life. Why did you not do anything? So they believe that he knows more than he's letting on. Obviously, the prosecution does as well. And that's really these allegations made in those, or the things that he said in those phone calls, as well as, statements he's made to the grand jury that we talked about yesterday, and witnesses making their own statements yesterday. All those things kind of working to form that conspiracy to commit murder charge. And there's definitely a difference there versus the complicity to commit murder charge that Brooks Houck is facing in this case. Again, the ex-boyfriend, or rather then boyfriend, of Crystal Rogers when she disappeared in July of 2015. Lawson's son Joseph also faces a conspiracy charge in this case. And essentially, for viewers to note, that just means they believe he was a part of a plan to commit murder. Again, prosecution still trying to prove that in this case. They did rest their case after those bombshell phone calls. It seemed like the defense in that case really wanted to make it seem to them, to the jury, that you've already all heard this before. This is not new information. They're kind of making it out to be new information. We've already made these admissions. But I think it further emphasized for the jury the gravity of the allegations when he's sitting there talking to people on the phone about these things nearly 10 years after Crystal Rogers' disappearance. And it obviously was very emotional. We heard from Sherry Ballard, or we didn't hear from her personally. Rather, she walked out the courtroom in tears. A lot of these things, of course, as the family of the victim, you just don't know about them until it happens in trial. So it's become a very emotional time, no different than yesterday when they were hearing witnesses make these claims about what Steve Lawson has said before.
For sure, Alina. And to your point about, how Sherry Ballard, obviously, the stakes in this for her, given the heartbreak that she's endured. I'm just curious if you think, from your angle, as you've been seeing these reactions play out in the courtroom, not just to the literal testimony we're hearing about the jailhouse calls, which is a conversation, a legal analyst, our team, we can kind of see where a prosecutor defense kind of parses through that piece of testimony. But I wanted to ask you just your impression if, let's say, a Sherry Ballard is reacting as she did just to this testimony about a jailhouse phone call. Are you getting a sense with the jury's questions or sort of, how they're reading what the prosecution is doing? Is there a sense that there's been some testimony, some bit of testimony so far that you think might be, I guess, let's call it the one that outweighs anything they've heard so far? Do you think there might be something like that they've heard from the testimony?
That's a great question, Jose. Actually, yesterday was the only day we've had two two witnesses in which the jury has had questions for them. One of them was Elizabeth Chesser. Now, she had a baby with Joseph Lawson, and her mom dated Steve Lawson. And if you recall correctly, she's the one who said that Steve Lawson admitted to her that the reason he wanted to leave Tammy Lawson, his wife, who has since died and had died at this point when he was making these statements to Chesser. He said that Tammy knew he had committed murder, and that was a big moment for the jury. In fact, they actually asked her to say exactly and she put it in quotations, what exactly was the verbiage he used when he made that statement to you. So her testimony specifically really stuck with them, I believe, but it's hard to say in what way, because the defense really pushed her and wanted to kind of catch her in a confusing place. It seemed like they pressed her on, did you form a lot of these opinions from watching a documentary? And obviously we know there's a lot of documentaries, podcast episodes out there about this case. They really wanted to know, did you learn a lot of the information from watching those things or from hearing things from people who live in Bardstown, considering she is so close to two of the suspects involved in this case. And one really big moment, of course, was when she said that during a break, so her testimony was in two parts, they took a break in the middle after she made that jaw-dropping moment of, he admitted to me that he committed murder. They took a break. The defense wanted to dispute that or object to that. They had to take it to the bench. We took a break. And then during that, she had actually approached Sherry Ballard somehow in the hall, gave her a hug. Sherry said thank you to her. And she basically said, I hope that this testimony brings you some kind of peace, but I doubt that it will. And that was a big moment for the defense. They were taken aback by that. They did not realize she had spoken to somebody. And typically that's not allowed because witnesses are supposed to be under sequester. So that was an odd thing for that to happen mid-testimony. And I think that really struck a chord with the defense, and they actually did retain her as a witness, and they have the ability to recall her, which, we don't know yet if they're going to do that. They have only put up one witness so far in their case, which they made early this afternoon, and they're expected to call at least two more tomorrow before we get into closing arguments. So will Elizabeth Chesser be called? We don't know. All we know is that she has been retained as possibly being recalled to the stand.
Fascinating points there, Alina, and thank you for breaking those down, so eloquently and understanding all the history and the connections, the relationships with a lot of the people involved, not just Stephen Lawson, and how it extends with Joseph Lawson, Brooks Houck, of course. I did want to ask you something that just stood out to me because, and just so you know, in conversations I've been having with Leland, it's part of all this extended coverage we're doing, perhaps he was surprised at how fast it seems the prosecution's moved through their witnesses. And we know today we heard from an expert witness, Dr. Reich, and correct me if I'm saying that name incorrectly or not, but it sounds like correct. He's an expert in forensic analysis. Now, to you, did anything stand out from, what he had to offer to jurors? And this might lead me to the next question is the fact that the expectation was there'd be two more witnesses today, but they weren't there. Was that at all a surprise to the judge, to the courtroom? Did that take you all by surprise?
Well, I do want to say on Dr. Reich's testimony specifically, it was interesting how that kind of played out. I think the defense was trying to use that. Obviously, we know that they have argued that the hairs found in Mr. Rogers' car that were not tested should have been tested. And they really tried to kind of make Dr. Reich say that to some extent to the jury. I think he kind of did in a way of when pressed about it, he said, I don't know the evidentiary value of those hairs. And the prosecution actually, kind of fleshing out there could have been thousands of hairs in the car. What's the difference between the thousands and the two? But he basically wanted to say, when the hairs are present like that, I don't know the evidentiary value, but with any evidence, any possible evidence at any point in time, as the years go by, it kind of degrades. And he did make that point for the jury, but obviously the prosecution coming back and saying, you say, you don't know the evidentiary value, you don't know the full span of this case, and the defense in this case has already admitted that their suspect was at the car and moved the seat in the car. So at some point was in the car. And that was a big point for them today on Dr. Reich's testimony. So I think that's kind of the main point of his, in the end, that it didn't really have any shocking moments necessarily to it. But, the judge did deny the testing of those hairs in an order not too long ago, and the prosecution had called the defense's motion to test those hairs a delay tactic. So we do know those hairs have not been tested. So I want to wrap up that moment there. But when it comes to the other two witnesses that were supposed to be here and were not, they didn't really say why, and it wasn't really made a big deal necessarily in court that they weren't there. It was just, okay, this is a surprise. We didn't know they weren't going to be here, so jury, we're going to send you home early. Now, when it comes to that, there could be any number of reasons. I want to kind of lay it out for people who maybe haven't attended a trial or haven't been called as a witness before. Usually when you're sequestered as a witness, you kind of know the day and maybe even the time frame you might be called, because either the prosecution or the defense both are kind of mapping out how they're going to structure their case. So in this case, I think it was maybe something to do with that. We don't know who the witnesses are. They could live far away and couldn't get here in time. Again, this case is moving rather quickly. Everybody has remarked on that, even the judge himself. So who knows really the reason why. We do know the defense earlier did ask for a 2-hour break. So we ended at 10:30 when the prosecution rested, and they actually asked for 2 hours to try to get their case together to present it. So I think that it ended faster than they anticipated, that the prosecution rest faster than they anticipated, and that could very well have to do with why we didn't hear from those two others today. But we do expect to hear from them tomorrow, so I want to make that point clear.
No, for sure. And I think it speaks to how we will be there for however fast or slow this all moves. Of course, tomorrow at the end of the week for court business, but you and the team will be there. Again, so much valuable insight. You really giving us a sense of what's going on and what to really pay attention to. So kudos, of course. Big thanks to our Wave News reporter, Alina Noakes, in Bowling Green, keeping tabs on what has been day 3 of the Stephen Lawson trial, heading into day 4. And who knows how much longer we will have to wait until the jury reaches its decision. Alina, thank you so much. We'll be in touch. Hope you get your rest, of course, but we'll be in touch throughout the night and tomorrow, okay?
Thanks, Jose.
And our thanks again to Wave reporter Alina Noakes, really our eyes and ears down there in Bowling Green in the courtroom, along with our photographer and our producing team. The breakdown right there, fascinating points, conversations, especially over the phone and among the witnesses there. So we'll see how it all plays out looking ahead to day 4. Hope you stay with us after the break. I'm going to show you part 1 of my conversation, discussion, and breakdown today with our Wave legal analyst, Leland Hulbert. So stay with us as we take a quick commercial break. We'll be right back. All right, folks, welcome back to this latest edition of Wave Extra. Again, day 3 of the Stephen Lawson trial, as has been from the start. Always thankful for the inside analysis from our Wave legal analyst, Leland Hulbert. Leland, day 3, and of course, there's more testimony to break down. Broadly, I did want to get your thoughts on what seems to be, the centerpiece of the discussion today was around jailhouse calls and cell phone calls. So take it away for as far as, as you've been processing the notes with us based on the questions we've been asking you all day, and I've got the notes here as well. Anything from what was said in court, or just the value of when you're discussing the cell phone call like this, or even the jailhouse calls for Lawson in regards to his mom and the unknown caller that was discussed? What are your thoughts?
So when you have statements of a defendant, I think they're damaging. Or they can be damaging, because you have a man sitting there, usually in a suit or dressed up, and they don't hear anything from him. You don't know if he's a good or bad person. You don't know his character. And then you hear, sometimes you have more of a stoic image of that person. And then you hear his voice, and you wonder if he is polite. You wonder if he is rude. You wonder if he is angry. You wonder if he is docile. So this person, Mr. Lawson, talking to his mother and somewhat confessing to some involvement as related to the car and other things, I think is damaging. And I think his attorneys realized that, which is why they fell on the sword early with the tampering, and they didn't want to fight that. And they wanted to admit some fault, because you can't undo a statement of a defendant. You can explain certain things, but his words are his words. And why he talked on a jail call, I mean, I was asked that by both of the anchors earlier, and it's shocking to me how many people still call on the phone. They get a prompt that says this is being recorded, and then they spill, not everything, but they start talking about their case, and I don't know if it's guilt. I don't know if they feel like their goose is cooked now that they're behind bars, but it happens quite a bit.
And you and your, in a hypothetical with being a practicing attorney, if that was sort of some advice to give a potential client, I'm sure you would tell them, like, understand, like, you have the right to make phone calls, to reach out to your attorney or whatever, but this phone in particular, it comes with these conditions, perhaps, right?
So a number of my clients are in custody when I get the call, and I usually get it from a family member. And first thing I tell them once I've been hired is, you can't talk to him anymore about this case. Everything you say is being recorded. Nothing good can come from that conversation. And there's other problems with it. But the main thing is, the prosecutor has an office and has a team of people that are reviewing these cases. It often comes up in domestic violence cases because a defendant will call the victim and say, I'm sorry, or say this, or start admitting to things they shouldn't. And, the right to remain silent goes away pretty quickly when you start talking and it's recorded. And the jail, to their credit, tells you it's being recorded. It's not some sort of hidden secret. It's being recorded. They know it's being recorded. And so shame on them. And I feel sorry for defendants that do it, because it just lines them up pretty quickly to have culpability.
For sure. There was something, and there might be some more connection points as we go through day 3. I did want to ask you just, it's a term I've heard in other cases before, and not to necessarily sidebar from what we're discussing with Mr. Lawson's case. What was interesting, I was having this discussion with Alina, and she's been in the reporting about Brooks Houck's sibling, Nick Houck, and his mother, Rosemary. And so the term I've heard discussed now based on testimony today, unindicted co-conspirators. So for the layman out there who this might perk their ears up and saying, okay, there's something else to look into and pursue. But what does that term mean, unindicted co-conspirator?
Well, in the basic sense, it means that they haven't been charged yet and they're persons of interest. To me, as an attorney, it signals they may have given statements, they may have given information, they may be on the hook for the second trial. They clearly have some suspicion, and usually it's more than just suspicion for a prosecutor to call them an unindicted co-conspirator on the stand. And I think one of the investigators was asked, would it surprise you to know that they're potential defendants? And the detective said no. it wouldn't surprise me. So, this wasn't, I don't think the prosecution is trying to say this was three men in a vacuum. This was a family. This had it was a web that reached to a number of people that had relations to this family.
Yeah.
And it seemed like kind of a family affair. And that doesn't surprise me, because once you start asking for help, the people you're going to tell what you did typically are your family. The people you're going to ask for help, who can you trust? Your family, theoretically. So it doesn't surprise me, but the prosecutor is not going to charge 20 people. And you see this a lot in federal court. But most of the time in federal court, those unindicted co-conspirators have given a statement. So have these people given a statement? Presumably the defense would know that and would be given their statements if they made a statement, whether or not they're indicted or not.
Fair enough. The question you and I had been discussing this week with cell phone data, location pinging, there was a mention with this, I forget if he was an investigator from the attorney's office, Mr. Schaefer. And so placing Lawson, his cell phone, 4 hours on July 4th, where, after he left Bluegrass Parkway, the defense sort of trying to bring out the point, the cell phone, the report only shows a location of a phone, not if the person is holding that phone. Is that a fair distinction to make during testimony in a trial like that?
I think you better make it if you're a defense attorney, because the assumption is you're with your phone. And most of us are with our phones 90% of 95% of the time. So if you're not, or if you don't want your client to be pinged to that phone at that time, you point that obvious fact out that someone can take your phone and have it. Phones are transient. They're not locked to you. They're not tied. They're not sewn into your body. They can disappear. They can go in different places. And presumably that's the defense's argument, that we know the phone was there. We don't know who was with the phone. And they could argue that Brooks Houck or someone else was trying to pin this on other people by taking their phones or taking Crystal's phone, or, so phones can move around. And obviously in a murder, someone is deceased and their phone is still working. So they have to dispose of that. They have to take that. They have to move that. I'm not saying that any of these people did that, but her phone would also be an interesting thing to look at.
And to your knowledge, I don't think in Mr. Lawson's case, they've at least discussed that particular location, have they? Or was it a reference to what was manipulated with her car because of what was found?
I think the car has been discussed at length. The whereabouts of her phone may have been discussed. I obviously can't see the whole trial. I'm not sure. But her phone could potentially be downloaded. But the car is, from what I understand, a lot of people testified her normal habits with this car. People saw the car. And now you have Stephen Lawson admitting on a jail call that he moved the car seat to make it look like she was in it.
Yeah.
Obviously, that's not a good thing. That in and of itself alone is tampering. And that's probably why they admitted that early. It doesn't necessarily mean he had anything to do with the murder, but it's certainly not a helpful fact for his case.
For sure. This week, I took to heart when you mentioned with the prosecutor's strategy, or generally when you're trying to, build a story out for the jury, you want to, build to that crescendo. We know the prosecutor's rested today. To I guess, paint it with a broad brushstroke to say the jailhouse phone calls, and that is sort of the crescendo to the prosecutor's case. In your mind, does that make sense, at least based off of the audio they might have heard, and B, the text, if there was text and that's what they were reading, the exchanges between Mr. Lawson and his mom, or Mr. Lawson and the unknown caller? Does it make sense? You look at the breakdown of the questions that the prosecution would want this to sit last with the jury before they hear from the defense.
Possibly. I think it's more, the crescendo aspect that I mentioned the other day is you do want to sort of keep the jury interested and build your case. But the true crescendo or icing on the cake is closing argument.
Okay.
And the prosecutor is building points to make in a closing argument. And he's not done yet, because his cross-examination of any defense witnesses will also be included. But really, you're making a roadmap to a theme, and you argue that theme. using bits and pieces. So your closing argument is your chance. It's the last chapter of the story. It's the conclusion, and it's what the jury's going to remember last when they go into that room. The defense goes first and the prosecution goes second. So the last words they will hear are out of the prosecutor's mouth. And that's set up that way for a reason. And it's an advantage to the prosecutor.
Our first witness for the defense, if I remember just taking the notes here, seems like he's a background in forensic analysis. Sort of that discussion to sort of discuss perhaps Mr. Lawson's involvement with the car, which again, to the point we've discussed, they're not denying that he had the car in his possession and what he did with it. But they seem to then have this discussion as far as the hair and what was or wasn't tested. To you, prosecutors will follow their playbooks as they do and based off standards and good practice. Do you think that the jury's going to, is it going to stick at all with them, this whole point of what hair was or wasn't tested? Because that was a whole question with motion and appeal to, try and test some of that hair from before. And here's a defense witness saying, okay, they told the prosecutors, okay, it's possible to have been in a car. He didn't leave any hair behind. Testing Miss Rogers' hair, his hair. What do you make of all that?
I'd certainly make a big point about it as a defense attorney. I mean, I don't think we got a good answer as to why it wasn't tested. To say that it could be destroyed, that's why they didn't test it, I don't think that's good enough. I think they may have missed it. The question is, how big is that nugget? I made the comparison. There's 500 nuggets, maybe there's 50 nuggets, maybe there's 100, but there's a lot of pieces to the case. So I don't think that is going to win or lose the case. But the prosecution has to prove their case beyond a reasonable doubt. So the defense has to pry the door. I mean, no one's ever put a number on it, but you say you have to be guilty about 90% is about what beyond a reasonable doubt comes to, 95%. So if the defense can pry that door 5%, 10%, certainly not testing hair is a small pry of that door being open a little more. Now, I don't think it's enough to win or lose the case on either side, but it's certainly something the defense will mention in their closing.
Okay. Not that I want you to necessarily speculate, do we, based on putting the expert witness first for the defense, do you think they will follow a pattern with the profile of witnesses they'll call to the stand tomorrow?
The defense, one of the few advantages a defendant has in a trial is their case is unknown. They could pop Stephen Lawson at the last second and have him testify. I don't think that's going to happen. If they have an expert witness, they likely would have had to disclose that. So that's not completely unknown. But they can also have rebuttal witnesses. So if Sherry Ballard or someone said something, or more likely a detective said something that they want to dispute, they can call a rebuttal witness, and that witness doesn't necessarily have to be disclosed beforehand. So the defense's case is a little bit unknown, and that's by design, and that's one of the few advantages they have. But if closings are suspected tomorrow, it sounds like they only have one or two witnesses. I wouldn't expect some bombshell witness. It sounds like the witness can likely be anticipated by the prosecution, and that's preparation, right? So even if they sprung Stephen Lawson, the prosecutor knows the case backwards and forwards. He would probably welcome that opportunity, which is why it likely won't happen.
And I know we discussed, a theme from yesterday into today that, you wouldn't rule it out as an impossibility, but you just would highly doubt in the strategy to bring Stephen Lawson up to the stand. There was a question. I'm just remembering now when I was discussing with Alina a little bit earlier, but it sounds like, and I can corroborate all this, double check with her, but there was an aside having to do with some privileged conversations. I think she was hinting at, it doesn't seem like it's not meant to be public knowledge, but Alina was discussing something about at a point in time, the prosecution and Stephen Lawson had discussed immunity.
Right.
And so does, whatever that decision was or wasn't to make that arrangement at this point, I don't know if you think, what gain does a Stephen Lawson in this situation have going up onto the stand? I don't know what that conversation was because it's privileged, but what do you perceive?
I think the Stephen Lawson, were he to testify, could potentially say, well, this is why I said this, or this is why I told them that. They were promising me things left and right. But I don't think he's going to. I think the case is not a slam dunk. And if a case is a slam dunk for the prosecution, the defendant doesn't lose a lot by testifying. But it's still, you rarely see it happen. So this case is murky enough. And again, we're at a little bit of a disadvantage because we haven't watched it.
Right.
We're getting notes. But I would be shocked if he testified. And I think it's one of those cases that there's appealable issues as well, because the defense has asked for continuance. Mm-hmm. The defense has been denied the right to test the hair. The defense has been denied things before the trial. And if the defendant testifies, sometimes his rights remain silent and other rights go away. And that could hurt his appeal if the defense believes they have appealable issues. So to me, if there's 5 reasons why you would break that golden rule and have your client testify, I don't see a lot of those in this case.
Based on everything that's knowable to us at this point.
Right.
For any, at this juncture in a trial, for, any attorney or someone just following along in a case, is it worth trying to gauge what the jury is thinking tonight, what they're trying to process still, and what they will have to really ask themselves as the case wraps up?
Any attorney or any legal analyst who tells you they know what the jury's thinking is probably lying or misleading, because no one ever knows. If there's one thing I've learned throughout trials, when you interview a jury at the end, is the things that they latch onto are not always the things you would expect. And what goes on in the mind, I mean, it's hard to get 3 people to agree that the sky is blue and the grass is green,
or get them to pick where to go to lunch or dinner.
Right. Or much less 12 people to all unanimously agree that these crimes occurred. So the speculating what will happen, I think, is, we can guess, but, and it can be an educated guess, but based on what I've heard, I think we'll all be interested to see. Sometimes you can tell about how fast they rule. So if they rule in under an hour, they were pretty set. They knew what they wanted, and there wasn't a lot of conversation. This case, I thought it would take longer to present, so me predicting how long the jury will be out may be foolish, but I think they'll be out a while. And if not, they'll send a pretty clear message of what they thought.
Fair enough. Excellent. All right. Again, thanks for tuning in to our extended wave extra coverage. Day 3 now, the Stephen Lawson trial, heading into day 4 for Friday. And again, wave legal analyst Leland Hulbert joining me, waiting to see, if the expectation, Leland, of course, is the defense might wrap up tomorrow, but then heading into the weekend, and then by Monday, do you think that's a good gauge for we might hear those closing arguments?
I think the way this trial is moved, it could possibly be tomorrow. I mean, if they get started early in the morning and defense has 2 witnesses and that's it, there's no rebuttal witnesses, then the judge would likely want closings to be tomorrow, which is a whole nother set of psychoanalysis. Do you want a jury deciding a verdict at 3 p.m. on a Friday?
Right.
They want to go home. It's a nice weekend. It's summer. They don't want to be there over the week. Does the judge sequester them or let them talk until about 10 p.m. and say, come back in the morning? There's some interesting dynamics with a Friday jury. And I think it tends to rush a judgment a little more, or makes people even less agreeable because they don't want to be there. But usually in the first few hours, I think they feel responsibility. The jury wants to do a good job to start. And then once they get back in that room and start agreeing or arguing, things change. But we'll see. It's an interesting case study. I could see them deliberating tomorrow based on the speed of this, but no one really knows how long these defense experts or witnesses are going to take. So we'll see.
And then, of course, depending on whenever we do get those last statements from the defense and the prosecutors, and I mean, we have the team there, and we'll just have to play that by ear and rely on their intel as they're able to text us back. That's how we've been able to get these notes as quickly as we've been able to on our end.
Yeah, one of the best tea leaves I think that I've seen through these notes is juror questions, because some judges don't always allow juror questions, and when you have a juror question, you know exactly what your fact finders are thinking, or at least one person. And those questions can kind of tell you what are they thinking? What do they want to know? And sometimes I noticed when they asked the question today and the detective didn't have a real definitive answer, that can be some doubt. But it also tells you what they're focusing on. So that if you're looking for some predictor, those can be good predictors.
Excellent. I appreciate you all joining us for this Wave Extra segment. Our thanks again to Wave Legal Analyst Leland Hulbert. We'll check back in with you as we move through wrapping up the week. And of course, whatever comes out on Friday, we'll make sure to get that to you, Leland. Thank you.
All right. Thank you.